Before I answer that question, I must confess that there may be some ground for accusal if I were to actually write an opinion on the book. I have some shares in this company called Chintan Chandrachud.
Chintan's cases talk about whether national security is a theme where the judges freeze a bit, go into chill mode, and government uses it as a get out of jail card for them. I think I would like to see in the next 10 years that balance becoming better.
Those who are taken, they may not be deserving, and many times those who are deserving are left out. As far as Collegium system is concerned, of course, Justice Chandrachud, very rightly, because he's still a sitting judge, and he said that since there is a judgment, he'll proceed on that presumption. But I am not a sitting judge any longer, so I can say that it needs reconsideration as far as this system is concerned, and whether India is the only country where judges appoint judges. That is one. Then presuming, actually maybe on papers and going by Indian conditions, it may be one of the best even today. But in its working, at the end of the day, let me be very frank and blunt by saying so. What Shekhar, you said about that, how we get to know about the, as far as a particular judge is concerned, from High Court to Supreme Court if he has to come or she has to come, or from District Court to High Court. As Dhananjay also said that, yeah, we have the process of evaluating their judgments, etc. But still, I would say most of the time we go by our impressions. It may not be a scientific study made about a particular candidate, if the candidate is chosen from the bar or from the bench when it comes to Supreme Court. And the Collegium goes by this, and therefore many times those may be aberrations. Those who are taken, they may not be deserving, and many times those who are deserving are left out. So that needs to be taken care of, and something has to be done.
I think we do need some, given the range of issues that the court is deciding, particularly our higher courts, we do need some kind of, just having judges or just being a great lawyer is not necessarily going to make a good judge. So when you have issues like 377 or environmental issues, or issues which a lawyer may not have, the legal knowledge alone is not enough. You need a lot more social sensitivity. And therefore, I think the system has got to be able to pick up people who may be able to assess, as to whether a person has a good sort of social sense, a breadth of experience outside of the courts. That's important in our system particularly. And when we talk of diversity, I think, particularly when it comes to women, it's interesting that a couple of weeks ago, I met a senior counsel, a woman, who mentioned that she had missed out on judgeship because she spent the first several years, being a stay-home mum because she wanted to be with her child. And then by the time she got into practice and did very well for herself, it was just too late. So should the age be the same for men and women if women have families? How are you going to take care of that? And we may be missing out on some very good candidates because we don't take that into account.
Every Friday, I have presentations by my law interns once a week on some contemporary issue of law. And it's just a reminder. I mean, much of the presentation that I hear is very trenchant in its criticism about the courts and about the Supreme Courts. And I began by becoming very defensive about it. And then I realized, it's important that we open up ourselves to a dialogue with the wider society. And I think this is what this kind of legal scholarship really does, which Chintan's book attempts to do. Courts, I think the central theme of the book is this, that increasingly courts have not just become social institutions for the resolution of conflicting claims over private rights or over conflicting claims over public rights, but we have become institutions for social engagement. And that is why perhaps there is so much of critique about the courts and the work that the courts are doing. Because it's not really just about resolution of individual cases, but these institutions have now become focal points of a social dialogue. And if we look at this transformation which is taking place in the position of our courts today, particularly of the Supreme Court, I think that's when we realize the need for a greater engagement of the work of our courts, the constitutional courts, with the life of society. And I think partly because of the nature of the judicial role, we have been insulated from society. And I think that insulation is good insofar as your work is concerned as a judge, that nobody can call you up and tell you what to do. But equally, that insulation should not be taken to a point where the meaning of the work which courts do doesn't get transformed into the lives of society.
I can think of two sequels to this book. One of them is The Cases That India Forgot, Part 2, in a decade from now. And the other is The Cases That India Forgot to Decide. And let me start with the first one is, and my concern is, that the right to privacy judgment, which is perhaps the most significant, the most canonical judgment over the last decade, will be forgotten and will not be implemented in spirit. And the right to privacy judgment is one of those unique cases where everything is at stake. It's whether a fundamental right to privacy exists, but also on the other hand, nothing is at stake because there's no issue or list for the court to decide. And my concern is that the lofty principles and significant principles articulated in the court's judgment will not be applied robustly in practice. So it's one thing to articulate principles of the highest order, it's quite another to apply them robustly in practice. So that's the fear that I have. The other sequel could also be The Cases That India Forgot to Decide. And this is really a matter of priorities. Now remember, our court is like no other Supreme Court in the world. India's Supreme Court decides more cases in one day than the UK Supreme Court decides in the whole year. What that means is that there's naturally a queue, and some cases are more important than others and are heard before others. What this results in is that significant cases are often simply not decided, are simply not determined until it's too late and you reach a situation where the issue is irremediable. And so therefore I think this idea of judicial avoidance is also something we need to think about. And the good and bad decisions that the court has taken also need to be considered in tandem with the decisions the court has simply avoided.